Funga mti bro. Funga mti. Funga mti.
Tuna ng'ombe jao.
Naona
How are you? Jambo. Yes. Salama? Yes. Yeah. Karibuni mtuambie. Tumekuja kuwasalimia. Yes. Tulikuwa tumeandika barua. Sema tunakuja kukunywa chai tukiongea na viongozi wenzetu. Oh. Hapo maybe. Okay. Kama na dress. Okay. Sisi hatuna maneno. Yes. Hata sisi hatuna maneno. Yes. This land in Kenya. Yes. Waenda wapeane hiyo memorandum. Watu wengi social distance. COVID bado inaenda juu. Andika barua vizuri kwa clerks na speakers. Tukasema tunataka kuongea na wao juu ya maneno ya sheria inafanyika kwa nchi yetu. Unaona tuko na wanasheria na wananchi wengine ambao wanapenda sheria kwa hii nchi yetu vizuri, na tumekuja na utaratibu kama viongozi tuongee na viongozi wenzetu, na tulisema kwa barua tuko watu 20 mkikaunti.
Because we all speak Kenyans, so we welcome them and we always want to consult. Two is to say that following the advice of the Chief Justice of the President of Parliament under Article 261 on issues which you are aware, we went to court ourselves. We have gone to court under petition E300 to ask the court to listen to our side of the story as well. And also we have other 3 Kenyans who have also gone to court. Konjela, there is the Honorable Olwod from Mathare, and the Attorney General. And we have ourselves conservative orders that the President should not take action until the matter is heard and determined. And I've told my sisters and brothers here that Parliament is law-abiding. We follow the law. The same constitution that gave powers to the Chief Justice to advise the President is the same law, the same constitution will go back to appeal and seek relief. And I was assuring them that to that extent, we really are unable to say members should not work, that Parliament should not do the normal duties, discharge their mandate, until such a time that this matter is heard and determined by court. 2, there are provisions in the Constitution that the presence of somebody who shouldn't sit in the chamber, by the way, and it was meant for people who have petitions, cannot invalidate the proceeding of the House. There are only 2 provisions that ends this Parliament. One is a function of time. After 5 years' time, the power to dissolve parliament is no longer in the constitution. But also under Article 261, the Chief Justice could advise the President to serve. And those are the only two. And this is at a time that those provisions of the constitution are implemented. Really, I think as an institution, our hands are here. And if you look at the constitution, the law, it says that it should be interpreted in a manner that really promotes human rights, public good and all that. I understand the feelings of my brothers and sisters, but we are all Kenyans. We have to subscribe to the constitution. I've said Parliament is law-abiding, and that is why we went to court to seek reprieve. We have been given conservative orders, and we believe that our colleagues here will also wait for us to be heard, so that whatever final decision that comes, then follow. Obviously, we cannot be preaching water and taking wine. No, really. And I am happy Honorable Mwete started by saying we follow the law, we follow the constitution. So I want to assure them that we will work together. The conversation will go on. Let us maintain law and order. Let us allow the courts to work independently. And whatever comes out of it, Parliament in fact cannot dissolve itself. Somebody else has to initiate that process under the constitution. And that Parliament is always open, not only in this issue of dissolution of Parliament, but actually looking for the answer to the problem we are facing as a country, as Article 27.
Challenged, not to make any more appointments that will be challenged, not to give the opportunity for impunity and disregard for the rule of law to continue prevailing in this country, and Parliament chose not to do that. So for that, asante sana Clark, and I think I'm really happy because now we move on without saying, you know, what you're saying in court is that you are not given an opportunity to be heard. And I think when we move from here, we will say that we did give Parliament an opportunity to be heard, and that was done.
Maybe then to...
My name is Marilyn Kamuru of We Are 52%. And as you saw, we had a meeting today with the clerk of Parliament. We are grateful for this opportunity. We had a fruitful discussion and we have explained our position about Parliament's unlawfulness based on Article 3.2 of the Constitution of Kenya. And they have explained their position as well. And we are clear that it is important that we continue to have a conversation that will restore constitutional order in this country and actions that will lead to the restoration of the Constitution of Kenya 2010, not continued abrogation of either constitutional provisions or court orders. So we're grateful to you as well for coming. It's been a long time waiting, and we are looking forward to decisions by Parliament, including perhaps suspension of things like appointments. It would be completely unadvised for Parliament to continue with business such as appointments while it remains unlawful, and it's unlawful not because of the dissolution pending, but because it is composed in violation of Articles 27(8) and 81(b). And that's an independent matter that is not before any court. So again, thank you very much. I'll let Esther speak.
Thank you very much. Go right there. Yeah. We're grateful. We're grateful that the speaker, the clerk, Mr. Sele, has given us an opportunity to listen to what we had to say, having indicated to him that we wanted to discuss modalities of how Parliament shall proceed with business without its members, who, as of today, no longer have the authority of the people of Kenya to speak on their behalf. He has indicated the position of the Parliamentary Service Commission that filed a petition before the courts. It is undoubted that the Constitution that we passed did not contemplate a challenge to itself. The Constitution under Article 2.3 indicates that it cannot be subject of challenge. Its legality or its authority cannot be challenged in a court of law. As the judiciary, of course, the judges will give their views on the petitions before them, but that's a position of the Constitution, it's a provision of the Constitution that cannot be challenged. And therefore, we believe that we shall proceed with the necessary actions that we have decided to undertake as of today, because legally Parliament has no authority starting today and cannot, anything that they do from today henceforth shall have no legal foundation. And for that reason, we will continue to speak the same message that we have been speaking. We invite many of those that believe in the Constitution, believe in that which we passed in 2010, to continue adding their voices to this agenda. Whether the President does what the Constitution has asked him to do or not, we, the people, are sovereign, and we shall continue to uphold the Constitution and the rule of law in this country. So I invite everybody, young, old, female, male, women, children, whatever it is that you are, you should come and add your voice to standing up for that which is right, to standing up for the obedience of the rule of law, and to standing up for this Constitution for which we struggled for many years and passed overwhelmingly as a nation. Thank you very much.
Together with ourselves, United Green Movement Party, and we are 52, the women lobby group that's been fighting for this 2/3 agenda. And we are very clear with the clerk of the National Assembly that Parliament is unlawful. They failed for 9 years to pass the 2/3 gender rule. Petitions were made, including a press conference by the United Green Movement's Women's League that gave the Chief Justice 14 days to write a letter to the President to dissolve Parliament. And the Chief Justice listened to our call, and within 12 days of us asking him to do so, he sent that advisory to the Parliament, to the President. So we came today to tell the clerk that while this matter might be before court, and the clerk has said that they also have a right to be heard as an institution, something that we agree with. But we're very clear as right-thinking Kenyans. Sometimes you don't have to wait for a court of law to make you do that which is right. We ask the clerk to sit down with the leadership of Parliament, the speakers, and other political leaders, and urge them to do the right thing. It is clear under our Constitution that Parliament is unlawful. What that means that any business they transact is illegal. Any person they vet into office will be holding that office illegally. Any budget they pass and money that is spent will be spent illegally. And we told the clerk that this is a mistake that is too expensive to make, because Kenyans will challenge those illegalities and people will have to bear that cost, even if it's in their personal capacity. And the clerk heard us. But what is most important today is we came to protest. And we have protested. And what we have shown the Kenyan people, that as young leaders, we don't have to carry stones, there doesn't have to be tear gas, and we don't have to have running battles to protest and stand up for the rule of law, for constitutionalism, and for us to do the right thing by the law. And we will continue engaging with this new kind of responsible leadership, non-violent, based on issues, to fight for what is right in this country. We told the clerk, let us as a country learn from our neighbors. Zimbabwe has had a coup. The people of Zimbabwe took matters into their own hands. Sudan has had a coup. Mali has had a coup. Ladies and gentlemen, let us not wait as Kenya to make those very expensive mistakes that these countries have made. And those three countries have had coups because of three reasons. One is because government refuses to follow the law. Two is because there was grand corruption in those governments. And number three is because there was an economic struggle. Kenya has begun to show a sign of all of those three. And if we as leaders don't stand up and prevent a situation in this country where Mwananchi takes matters in its own hands, it will take us 25 years, a whole generation, to recover from a situation which our three neighbors are facing. So let's be proactive. Let's come together as Kenyans. Let's make sure we stand up for our country and for our young people, because they are the ones who have the biggest to lose if this country goes into anarchy. And the only way we can do that, ladies and gentlemen, is by protesting when the rule of law is not followed. So we urge the president again. The constitution is clear. Follow Chief Justice Maraga's advisory. Dissolve Parliament. And let us protect our constitutional order that keeps us peaceful, that keeps us successful, and that keeps us respected in the international community of countries. Asanteni sana, and thank you for all following us in this very, very peaceful protest to Parliament. I invite the President of the Law Society of Kenya also to...
Today is a great day. It is a day that will go down in the history of the Republic of Kenya. The 12th of October 2020. Why do I say so? I say so because of several reasons. People start fighting when they stop talking. People litigate when they stop negotiating. We are here gathered peacefully because we started talking, we started negotiating. And may I return my gratitude to the Inspector General of the National Police Service and his able officers who you see here, because when I requested him on Friday to permit us to get entry and to facilitate our entry with adequate security, you saw he provided security. And the security officers here have been very civil. Secondly, may I return my gratitude to the Clerk of the National Assembly, Mr. Michael Silai. He extended his open arm to shake ours. He didn't put forth a fist to push us away. We have told the Clerk of the National Assembly that effective today, Parliament is illegitimate. Any person who until today was an elected member of the National Assembly or the Senate has ceased being an elected member. He or she is a trespasser. And Kenyans must realize that these statements we're making are not idle statements. These are statements based upon the propulsion of the law. The Constitution of Kenya must count for something, or it will be for nothing. Parliament has a right to go to court. Indeed, it is entitled to be heard. But it is a fundamental tenet of democracy that the minority will have their say, but the majority will have their way. What is the majority view of the people of Kenya? The majority view of the people of Kenya is that Parliament has failed in its obligations. There is rampant corruption. There is nepotism. There is cronyism. there is no development. And we are not limiting our struggle to the 2/3 gender rule. There are many other reasons as to why Parliament must go home. It has failed to oversight the executive. It has failed to hold the President accountable. The Clerk of the National Assembly has indicated to us that they have forwarded this matter to court, and for that reason they will abide by the outcome of the court. I'll be frank with you, I do not believe any word they have said. The only word I believe from him is the civility and the welcome he afforded us this morning. I say so because there have been so many decisions of the court in respect of this matter. But more importantly, Kenyans must understand the decision by the Chief Justice is one that cannot be challenged in a court of law. Just as none of us can take the President of the Republic of Kenya to court because of a decision he has made. For that reason, therefore, we don't see any bona fides in the claim that is before the court. But I must assure Kenyans that Kenya is a country governed by the rule of law. And the rule of law as it is right now is that an article of the Constitution can never be challenged before a court of law or before any other state organ. And if that be the case, then the only conclusion we can make is twofold. One, Parliament and the Attorney General are buying time through the court process, or they have ensured that the court process will deliver an outcome favorable to them. Let them know that if the latter is the case, then they still speak for the minority. The majority view is Parliament must be dissolved because it has ceased being legitimate, effective today. We have listened to the Clerk of the National Assembly. He has heard us. We will come back at a later date when we'll be able to deal with this matter with finality. But for now, we officially declare this house as belonging to the people of Kenya. Anybody who comes here as a parliamentarian will be a trespasser. You know what to do. If they come to your constituency, don't permit them to use public resources. They should not use our vehicles. Na askari na muomba, tafadhali msipatia watu ulinzi. Sababu hawa watu si halali kutokea leo. Mungu aibariki Kenya. Mungu aibariki katiba. Mbarikiwe sana. Na wananchi wa Kenya.
And then there is the issue of you being an officer of the court of law. Why were you?
That's a valid question. He has asked that I'm an officer of the law and why am I ignoring a court order? First and foremost, it must be understood that the Law Society of Kenya is one of the 6 petitioners who asked the Chief Justice to dissolve Parliament. We presented our petition, we presented our submissions. The Chief Justice asked Parliament and the Attorney General to file their respective legal arguments. They did not file any legal arguments. Now, when Parliament and the Attorney General go to court to sue the Chief Justice, you realize where the problem is. But more importantly, we have not been sued before any court of law in respect of this matter. No wonder, therefore, when Parliament sought to convince Justice Weldon Korir last Thursday to preclude us from coming to Parliament, the judge told Parliament that the Law Society of Kenya is not a party to this suit, and for that reason, I will not make an order against the Law Society. But fundamentally, it must be understood that the advice to dissolve Parliament was given to the President of the Republic of Kenya. There is nothing that stops the President of the Republic of Kenya from acting in accordance with that advice. He has not been restrained from acting. And I can tell you without any fear of contradiction, because I speak on behalf of 17,000 advocates. Between myself and the Attorney General, you're better placed to understand who between the two of us is speaking on a strong legal foundation. What we're telling you here is the law.
success, please?
Absolutely.
This is a great success.
Absolutely.
And I want to encourage all leaders, all the people of Kenya to exercise civility, because without law and order, the nation will degenerate to anarchy. And you saw we limited our number to 20 people because we are cognizant of the regulations that are in place. So this is a big success. And this success is not out of our making. This success is out of the making of two state officers, the Inspector General of the National Police Service, who commands all these good friends, and the Clerk of the National Assembly, who have embraced negotiation and dialogue, unlike many other leaders in this